guys, Hellville here. So, oop, let me turn that off. That's annoying. Um, oop, the sound is on my YouTube on the other screen, so I can make sure I could actually hear things. But of course, it's not quite a bit of a delay, so sorry about that. Anyways, hi. Earlier today, I did post. I posted a little video tour of my garden, since I talk about it a decent amount because like I'm a boring garden lady now, I guess. I don't know. Anyway, sorry, I'm still organizing myself. I was trying to like pull up the documentation so that I could talk about it. So I have the David Dringers, blah, 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 blah. I have the David Gingras stuff pulled up. I saw and watched that obviously Bruce had commented on this as well. And of course, the lovely ladies at True Wine and Crime Time / Court Couch. So while I was watching on True Wine and Crime Time, I actually also had the Court Couch playing on my phone at like triple speed. So I can get the watch hours for both of them. But yes, so ahoy, Bruce, ahoy. I see the comments, so that's good. Also, because I heard myself earlier by accident, which may have made a little bit of an echo for you guys. I do know that my microphone's working. So that's good. I'm not muted and I'm not sounding like a devil yet. Though I am a little bit confused as to last time I thought I had my like voice mod going and it didn't apparently work. So I was like, oh yeah, I'm so confident. This is what's happening right now. And then it didn't work. So you guys tell me if you hear this. Having the babies, if I don't hear back from you tonight. Yay? Nay? I think yes. Maybe not. I don't know. I guess we'll find out. But in any event, hello to Cindy over here, CLT Doc MD. And oh, yep, Bruce heard it. Okay, good. Confirmed. I'm not gonna look like an idiot again, maybe. I probably will. It's fine. And hello to Wallace as well. Bruce, AOL, did you get email from Mary Lankins? I am Mary Lankins. We are all Mary Lankins. No, I'm just kidding. I'm just feeling nostalgic and I changed my like email notification sound to be you've got mail because I felt like it, but it isn't because I hear it like 45 times a day. So I don't mind it. However, it's probably annoying for other people. I mind it a little bit. I got to start muting myself when I go places, or maybe just lower the volume of it or something. But in any event, hello to Wallace. And yes, Cindy also heard having the babies. Awesome. Bella's mom. Good evening to Bella's mom. I'm assuming Bella is the gorgeous black kitty cat, and I love me a gorgeous little black kitty cat, obviously. So welcome. All right, so let's do that, and then we will. Oh yeah, I guess I could just leave. I'm trying to figure out where I should actually put my voice mod app. on my screens. Maybe I should just like decrease the size of StreamYard a little bit and put it alongside StreamYard. I don't know. Now it's covering the chat. I don't know. Anyway, I'll figure it out. I am going to share my screen. I think Echoes is also going live later today. I don't know when they set up their stream, but I'm so sorry if I did step on Echoes' toes. That was not my intention. But anyways, I'm hoping to not have this one become like a 25-hour long stream. So, you know, that's goals. Will it go that way? I don't know. I guess we'll find out. Apparently I'm a yapper. To be fair as well, I work remotely, so unless I have a lot of conversations with a customer on any given week, this is pretty much my socialization unless I like see people. So this weekend I did see people, but yeah, so I guess I say more words to you guys than I do most other people, but anyways. Okay, so that should be sharing. And RIP to Maisie, my little black kitty cat. Oh, RIP Maisie. That's such a pretty name. Yeah, it goes live in an hour. Yeah, so I'm gonna try to like not be on too much into their stream or at all if possible, but who knows. But hopefully I'm gonna try to limit as much as I can so that way I'm not like, stepping on them. I don't like stepping on people. I do not. But yeah. Say cheese. Hello. Yep. I'm assuming you're gonna hop onto Echoes right after I'm done there. Or even before I'm done, that's totally fine. Hey, come back and watch on Replay Crew. That's totally fine too. If I go a little bit longer. Okay, so where's that? Okay. So the original filing that was made was from Gingles, the respondent's briefing regarding the motion to dismiss. And this was submitted quite a while ago in May. But I don't know if did people actually House of the Dragon. Oh, yes. I forget that Sunday nights. I just happen to be, a little bit more free on Sunday nights sometimes. Cause Friday nights I got social stuff going on sometimes. Saturdays and Saturday nights I do as well. And then, Sundays are a little bit more free. But anyways, yeah, so I don't know if this briefing really made it super big in on Reddit or on Twitter or whatever. But I don't really remember seeing the briefing, or if I did, it was quite a while ago. Me, my memory disability just can't keep up with all these filings. We just can't keep up with all these filings. But anyways, so just a little memory refresher. Oh Jesus, 16 pages. I'm not going to read the exhibits or the case law crap. Just trying to keep it short-ish. On April 30th, 2026, this court asked the parties to brief the issue of whether the court's supremacy precludes whatever that is, application in discipline proceedings. This pleading provides the respondent's position on this issue. To begin, the real concern here does not appear to be the supremacy, but rather the separation of powers. To rephrase the question, when the Arizona legislature amended this law in 2022, did this usurp the Supreme Court's exclusive authority to establish procedural rules for bar cases? That is a separation of powers issue, not a supremacy concern. However, supremacy as a separate issue is discussed below. As explained below, ARS blah, blah, blah does not violate the separation or distribution of powers clause in Article 3 of the Arizona Constitution. That exact legal issue was recently resolved in the state versus court case, not to be confused with cohort. I don't know. And Bruce has said, I want to make a video about the anti-slap denial, but I just haven't had time. Yeah. Is that the one that was responding to this one? Because if that's the case, then I'm reading that one next. I just flipped between tabs, but I keep forgetting that you can't see when I do that. So I apologize, but Anyway, if it's the one from June 22nd, then that's the one that's next. Okay, so I was getting hung up on court versus court. A case respondent mentioned on pages 2 to 3 of his reply in support of motion for leave to exceed page limit. Oh my God. They don't need more page limits. In court, the Superior Court, this is too much, found ARS blah, blah, blah was constitutional and did not violate our Supreme Court's procedural rulemaking authority because that ruling is correct, supported by other authority, including from the Supreme Court. This court must reach the same conclusion. Prefatory comment regarding supremacy. I really don't like that word. It just has some negative connotations to it in these this day and age. Anyway, before addressing the court's specific legal question about the anti-SLAPP law, an important preliminary comment must be made. In this court's order, the PDJ, I suck at acronyms. Why can't we just stop using acronyms? Anyway, the PDJ, whatever that means, repeated a line. Oh, wait, that's the bar people, I think. Yeah. Repeat a line mentioned in multiple prior pleadings or orders that the oath and creed are not aspirational but enforceable. It appears the bar cites this line as support for the idea that the Arizona Supreme Court holds unlimited, final, and supreme authority to adopt any rules it desires, and that the PDJ or the bar indeed must enforce those rules as written. Oh, wait, the PDJ must be the judge for the bar. I think that's the judge for the bar. Again, acronyms, they get me every time. It's so annoying. Okay. That view is incorrect as a matter of law. The PDJ's view is not wrong because it is inaccurate, but rather because it is incomplete. The PDJ is right. Wait, something weird is going on here too. Anyways, the PDJ is right about one thing, only one thing, just to be clear. They're only right about one thing, only one. The Arizona Supreme Court has admonished lawyers that the rules of professional conduct and lawyers' oath and creed are not aspirational. Fair enough. Who says that? Who says fair enough in a court filing? I mean, who says a lot of things that Gingles says, but especially a court filing is ridiculous. Fair enough, but that is not the end of this analysis. The Arizona Supreme Court is not the final, nor is it the supreme arbiter of the law. The supreme law of the land is not Arizona law, nor the pronouncements of the Arizona Supreme Court. The alpha and omega in a constitutional republic is the Constitution. The supreme law of the land is the United States Constitution because it says so, with odd capitalization from 250 years ago. Why do we have to mention the odd capitalization? That's stupid. Anyway, the laws of the United States shall be the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. The U.S. Constitution, Article blah, 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 the role of the Supremacy Clause is well settled. Under the Supremacy Clause of the federal Constitution, when a state law conflicts with properly enacted federal law, the state law is preempted. Here's where the concept of supremacy comes into play. The United States Supreme Court has spoken clearly about the limits imposed on the states by the Supremacy Clause. Disciplinary rules governing the legal profession cannot punish the activity protected by the First Amendment, and First Amendment protection survives even when the attorney violates disciplinary rule he swore. Even when the attorney violates a disciplinary rule he swore to obey when admitted to the practice of law. Hey, Rob, how you doing? Hey. Hope all is well with you. I see you're enjoying your, your AI artwork there over on your channel. If you're not subscribed to Hey Rob, go ahead and do that. He's got a great Arizona-based channel. So just reading the Rob says he's doing great. Awesome. Yeah, so just reading the respondents dismissal, this, that, or the other, the briefing, the dismissal briefing, because then we have the response to the briefing. So it's really boring, honestly. He writes so boringly. He thinks he's being so smart and clever and all that fun stuff, but it's just he's a boring writer. Especially because it's so long. It's always so long. But I guess Randazza's the one writing this. Who knows? Yes. So disciplinary rules governing the legal profession cannot punish activity protected by the First Amendment, and that First Amendment protection survives even when the attorney violates a disciplinary rule he swore to obey when admitted to the practice of law. Gentile versus State Bar of Nevada. Period. Thus, while again, period. Why the snark? It's not funny. Like it's just snarky, like, but without the humor behind it, in my opinion. Hellville, you read so good. It's clear and understandable. Great job. Oh, thank you. I'm so glad I'm literate. Yeah. Not all the time. Some of the time I'm not. It's fine. I try. Thus, the Arizona Supreme Court has correctly noted the ethical rules are not aspirational. The court was certainly not speaking as if they believed there was no supremacy clause, nor that their own actions were not constrained by both the Constitution of the state of Arizona and the Constitution of the United States. The constitutions themselves are not merely aspirational, and the U.S. Supreme Court's decisions in Gentile and Chiles versus Salazar, all the things, all the words, are controlling like your friend's husband is controlling and they should get out of the relationship, or controlling like they control the law. I think they don't elaborate on the things that they should elaborate on, and then they elaborate on the things that they don't need to elaborate on. It's just weird. Anyway. Yeah. Even the Supreme Court of Arizona, if it were to seek to find a way to overcome Gentile and Salazar, it would realize it had no avenue to travel that could lead around those decisions. See all these other court documents. The complete and accurate legal rule is as explained by the U.S. Supreme Court in Gentile is this. No matter what ethical rules Arizona Supreme Court adopts, those rules cannot punish activity protected by the First Amendment. Thus, while none of the ethical rules are aspirational, they keep using the word aspirational. My goodness. Oh, State Cheese says a controlling case is the one that must be followed. Okay, thank you. That's helpful. Not like a controlling husband that your friend needs to leave. Got it. Okay. I just wanted to make sure. Just wanted to make sure. Okay. While none of the ethical rules are aspirational in a general sense, the reach of those rules is always strictly limited by the First Amendment and by binding decisions from the United States Supreme Court. Having said that, this response will address the PDJs. Again, whatever PDJ means, I think it's the judge for the bar. Robert says, if you don't want to go to hell, hit that like button as many times as she's awesome. Thank you so much. I appreciate that. Yeah. Oh, my little banner didn't show up on the bottom this time. That's really rude. It should be on. There it goes. Okay. Should be on now. I also realized, and maybe that's why it didn't go on automatically, I had to edit it. I realized, and this is so stupid on YouTube's part, so I thought the hype button is supposed to be for smaller channels so that it basically like tells YouTube like, hey, we want you to actually like show this channel to other people in your algorithm. But apparently it's only available for people who are monetized. So how am I supposed to get to monetization without the option of my audience telling YouTube to play my videos to other people too? That's a question. So anyway, I have removed the word hype from my banner because it is not an option at this time. So make sure to share as well. Oh, I should have added that instead. Like, comment, subscribe, and share. Share with your family, share with your friends. Hey, if you have multiple channels, go on there and follow and like my videos on all of your channels. So that. But yeah, no one wants to go to Hellville. That's for sure. Oh, okay. Well, it says presiding district judge. That would make sense. Yep, that would make sense. Oh, presiding disciplinary judge says say cheese. Okay, that also makes sense. This is why I don't like acronyms. That's the thing. There are a lot of acronyms that mean multiple different things for the same combination of letters. So why don't we just take the question mark out of it and just say what we mean and mean what we say? That's my opinion on acronyms. I freaking hate them. I really, really hate them. Oh, Robert says it's on. Oh, it looked like it wasn't on before, but then I turned it on. But anyway, and Wallace said they were close. Yes. Well, I like if say cheese didn't come in with the real answer, I would have believed that. So it happens. Harvell, make sure you put in there that it's all free. Oh yeah. It is all free. Subscription, there's no charge. I actually can't charge anything at all until I'm monetized anyway. So you can't spend any money on my channel, period. There's no option for that at this time, unfortunately, as it is. So yeah, please subscribe. It's free. Oh yeah, I figured that was a misspelling. That's totally fine. It's kind of like Marvel, like you mash up my name with Marvel. Which, hey, I'm a Marvel nerd, so that's all right. I'll accept that. That's totally fine. Yeah. So the presiding disciplinary judge, now we know that is what that means. Having said that, this response will address the presiding disciplinary judge's specific questions concerning the legality of the anti-SLAPP law. So here we are on page 4. Is this page 4? And we are just now beginning to make the argument. I don't really feel like reading this whole thing. Anyway, whatever, I will. Although the presiding disciplinary judge referred to the issue of supremacy, which does play a role in this case for the reasons explained above, the question concerning this law does not implicate the supremacy clause. The question involves the separation of powers. I'm not going to read the case law. I'm just not. Lear v. Fields, more case law. The legislative branch makes law. The executive branch enforces law. The judicial branch interprets the law. Thank you so much. I'm 5 years old. The Arizona Constitution mandates that each branch is generally separate from the others, i.e., each is forbidden from exercising or usurping the powers of any other branch per Article 3 of the Arizona Constitution, but with some allowable overlap, i.e., courts certainly play a role in enforcing laws. It'd be really weird if they didn't. How would that system work? Under Article 3, the Arizona Supreme Court cannot create new substantive laws, but because that is the legislature's role. However, the court can adopt procedural rules, i.e., what font colors are permitted, how long a brief may be, and so forth. Oh boy, did Gingles get in trouble for that one a while back, hey? Anyone remember that one? You're not allowed to use bold, you're not allowed to use colors, you do it again, I will not read anything you submit. That was a fun one. These rules are simple and clear enough, but with at least 2 important caveats. First, the legislature can always create or change substantive law, since that is not a power held by the Supreme Court. Second, the legislature can also create procedural rules for the courts without creating a separation of powers problem, as long as the legislature's rules do not directly conflict with any of the existing Supreme Court rule. And Hey Rob says, simple and clear for me, but not all, obviously. Well, you know. It happens. You're so smart. Okay. Well, as long as the legislature's rules do not directly conflict with any existing Supreme Court rule. Briarcliff is illustrative. That case involved an Arizona statute created by the legislature, which prohibited criminal fugitives from appealing convictions if they fled the state. The defendant in that case was convicted and fled to California, where he was later arrested. He attempted to appeal, but the state moved to dismiss, claiming that rule barred the appeal. In response, the defendant argued is unconstitutional. The law or rule is unconstitutional because it's a procedural law that usurps his this Supreme Court's rulemaking authority. That is the same separation of powers concerns that the presiding disciplinary judge raised here regarding the anti-SLAPP law. The Supreme Court rejected that argument, noting the legislature may properly enact statutory procedures that supplement rather than conflict with rules this court has promulgated. I did pretty well on my SATs in the, the written section. I was like the first year that actually had the written section. I also did really well in the verbal section, and I've never seen that word ever before. Rob says, we're all on a learning curve, Hellville. Don't worry. Yeah. I'm learning. I learn a lot of things from all of my YouTube friends that have been reporting on this case. And I also actually used to be interested in possibly becoming a lawyer. And then I realized that the entire profession is like homework. And that has never been a strong suit of mine. So I have not, I did not go into that field. I went into an artistic field instead, and it was torture. And now I'm in a completely different field, and I love my job. So it happens. And when I say completely different, I don't mean legal. And Seichi says this is such a condescending filing. Yeah, every single thing that Gingles touches is condescending. That's just how he rolls. He's a condescending prick. But anyway. So the Supreme Court rejected that argument, noting the legislature may properly enact statutory procedures that supplement rather than conflict with the rules the court has promulgated. Hopefully I said that right. Anyway, the court found this rule did not conflict with any existing rule of criminal procedure. It only supplemented the rules by adding a rule where the Supreme Court had not yet spoken. As such, the Briarcliff Court held the law as constitutional. This was true even though the law was procedural in nature and even though it was created by the legislature. The court held the law. The court held the law. Oh, the court held that the law did not usurp its rulemaking authority and was thus valid. See ID. Identification? Anyway, Wallace says, oh my God, homework, the career, what a nightmare. Yeah. Homework was literally never my strong point. I got in trouble all the time. Every single report card I've ever had has always said, a pleasure to have in class. However, never does homework. So sucks. That's paraphrasing on my end, but accurate. So, yeah, that I realized that basically you're in elementary school, you're doing homework to continue on in your educational career to get into middle school. In middle school, you're doing homework to continue into high school. In high school, you're doing homework to continue into college. In college, you're doing homework to continue into law school. In law school, you're doing homework to continue into a really good law firm. And then once you're in a law firm, your entire job is homework. Not good for a person who does not like homework, huh? And never did it. I was very defiant. My parents hated that about me, but anyway. Oh, okay. Seichi says ID is the same previous case cited. Okay. ID. Okay. Well, Wallace says, the classic undiagnosed ADHD report card. We all had them. Oh no, I was diagnosed. Diagnosed and medicated. That's the thing. Crazy. Rob says, Hellville. It's a circle of life. Better get my name right the next time. It's fine. It's funny. Actually, I think at this point you should misspell my name every single time as like a joke. But anyways, yeah. So ID is the previous case cited. Okay. Okay, I'm not sure exactly where I left off, so I'm just going to start out with the holding of Briarcliff is simple. The Arizona Supreme Court does not possess exclusive authority to create procedural rules. As the court itself explained, the legislature may also create the rules for the courts, provided the legislature's rules does not directly conflict with any existing court-related rule. Only when a direct conflict arises is there any need to consider separation of powers. That is the case here. Nothing in this rule conflicts with any procedural rule applicable to this proceeding. It merely supplements the rules. Supreme Court Rule 48 adopts some civil procedure rules for use in discipline cases, but nothing in Supreme Court Rule 48 prohibits the application of any substantive Arizona statutory law. That makes sense given the multiple Arizona okay, I feel like you should only be allowed to use either all italic when you want to bring like attention to something, or all underline or all bold. And italic should also be reserved for the name of cases. So if you're going to try to bring attention to a particular word, it should either be bolded or underlined, period. That's it. I don't know. That's my it's too complex the way it's written, in my opinion. It's very hard to differentiate. Hey, Rob said it's my voice to text. It types the wrong word every time I say your name because it's a bad word. Oh, that's okay. Talk to text. We have beef now. That's so funny. Looks like Echoes and Jeep Daddy are starting a stream. You should join forces. Oh yeah, I would love to. I don't have a link with them. And vice versa. I should definitely reach out to them on Discord on the next stream, I guess. But I guess I'm going to continue here. So I don't know how to join a stream. I guess I can send a link to someone else's stream, but I don't know how to join someone else's stream unless I like receive a link myself. When did they schedule theirs? Because I don't think I saw anything when I scheduled mine for theirs. I do try to like not, I mean, there's so many people covering it, like eventually people are definitely going to overlap, but anyway, it's fine. It's fine. If you need to jump, feel free to do so. Just catch me on the replay. Not a whole lot I can do about that at the moment, unfortunately, but it is what it is. Yeah, I don't have any messages from them, but I don't know if we're actually connected on Discord. I don't think we're connected on Discord. Oh, you know, I was looking for them in the other group chats and I actually couldn't find them. So, anyway, if you gotta jump, you gotta jump. That's all right. Oh, you just saw it pop up today. Okay, so okay. Well, look, I'm not mad at anyone. It's literally just like, you know, I tried to make it. I just wanted to make sure I wasn't accidentally scheduling it on someone else's toes. That's all right. And Say Cheese says, gotta run. See you later. See you later, Say Cheese. All right. Yeah, so I was getting hung up on their excessive use of italics and in different circumstances. So that just itches my brain in not the best way. Everyone hydrate. I could tell my vocal fry is coming out, and I don't really want to sound too much like Laura Owens, despite being told that I actually have done the best vocal impression of her thus far in this community. So that's a little bit concerning on my end. So anyway, um nothing in ARS conflicts with the procedural rule applicable to this proceeding. It merely supplements the rules. Supreme Court Rule 48 adopts some, okay, I read this part, some civil procedure rules for the disciplinary cases, but nothing in Supreme Court Rule 48 prohibits the application of any substantive Arizona statutory law. That makes sense given the multiple Arizona statutes can and do apply in discipline cases. As just two examples, clearly ARS, this one prohibiting perjury applies here, as does ARS, whatever that is, making an award of attorney's fees mandatory for a prevailing respondent in a bar discipline proceeding. Supreme Court Rule 48 does not exclude those statutes from applying in discipline matters. If it did, then would we say perjury or fee shifting no longer apply unless the Supreme Court of Arizona makes its own rules pertaining to those subjects? Of course not. By the same logic, the anti-SLAPP law can only apply here without running afoul of separation of powers. Someone like message me on Discord or something? No. Okay, just double checking. Okay. He said, of course not, in the most condescending way. Okay, that's where I was. ARS, this rule does not conflict with any existing procedural rule. It merely supplements those rules as approved by this case. It is therefore constitutional and valid and must be applied as law. Although ARS, this one, is relatively new, having been amended in late 2022, the law has been applied without much difficulty, at least in one recent civil case. See this case. Discussing and applying an anti-SLAPP law in a civil defamation case. The Court of Appeals did not consider whether the anti-SLAPP law was constitutional in Lucky's because that argument was never raised by any party. Probably because the answer was so obvious. Oh, he's so condescending. I hate these people. Why are they so rude? Anyway. However, if the anti-SLAPP law was not constitutional because it infringed the Supreme Court's rulemaking authority, the Court of Appeals could not have reached the conclusion it did in Lucky's. Indeed, if the Arizona Supreme Court really has sole and exclusive authority to establish all rules that govern legal proceedings, the anti-SLAPP law would be invalid in every case, not just bar discipline cases. Thus, the fact that the Court of Appeals presumed the legal validity of this rule weighs heavily in favor of this court reaching the same conclusion. As respondents' anti-SLAPP motion noted, the other states with similar laws, such as Texas, have held that they do apply in bar discipline cases. Holding the Texas Citizen Participation Act, or TCPA. Ugh, not another acronym. Okay. A law similar to this one applies to the commission's disciplinary proceedings against an attorney. Yeah, my screen is like flickering again. I feel like there's an issue with StreamYard, but I have no idea what the issue is. Okay. And more cases, more case laws. The TCPA was enacted to safeguard the constitutional rights to petition, speak freely, associate freely, and otherwise participate in government from infringement by meritless lawsuits. We don't see the flicker, at least. Well, it's funny because I went back and watched to see if I could see the flicker on one of my previous streams, and I did see the flicker. So I don't know. Maybe it shows on some people's screens and not others. I don't know, but okay. Well, so many laws, so much homework that I didn't want to do. Even more helpful is the case respondent mentioned just weeks ago, State versus Court. Maricopa County Superior Court case pursuant to Arizona Supreme Court rule. A copy of is attached in Exhibit A and is available online at this link that is hidden by the website, probably. Court is helpful because the case involved some of the issues, because the case involved the same issue raised by the presiding disciplinary judge, whether ARS invades the Arizona Supreme Court's rulemaking authority. The Superior Court easily determined the answer to that question was no. The defendant in Court was arrested and charged with trespassing after she attended a protest at Arizona State University. She then invoked this rule, claiming the charges were substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right, meaning her First Amendment right to protest. The trial court, a justice court, found the defendant made a prima facie, facie or fasci? Fascie or fasci? Okay, whatever. Showing as required by law, and the court set the matter for an evidentiary hearing. The Maricopa County attorney then filed a special action in the Supreme Court, arguing, among other things, that ARS, this rule, was constitutional because it violated the Supreme Court's, was unconstitutional, sorry, that's important, because it violated the Supreme Court's exclusive right to adopt procedural rules. The Superior Court rejected that argument. I'm not going to read their rejection. We just need to know it was rejected, in my opinion. Of course, as noted above, the Arizona Supreme Court does not possess the exclusive authority to create procedural rules. As long as a legislatively passed procedural rule does not conflict with any existing rule adopted by the Supreme Court and does not abrogate any existing rule, the legislature is free to adopt any rules it deems necessary. In that case, if the Supreme Court deems the legislature's rule to be bad policy, the court can simply reject it, assuming the rule is procedural, since the Supreme Court has no authority to create or change substantive law for policy reasons. Conclusion. Oh, thank the Lord. Conclusion. These people can finally come to a conclusion. It's a miracle. It's probably the longest conclusion anyone has ever seen, or maybe not, because it seems to end here. ARS, this rule is plainly constitutional. It was passed by the Arizona legislature for the express purpose of protecting the First Amendment rights of all Arizonans, including lawyers. Probably not during the case you're talking about, though. I feel like there's like a conflict of interest with what they're arguing. It doesn't make sense to me. Anyway, the law prohibits state actors from retaliating against any person for exercising constitutionality. Why can't I speak today? Constitutionally protected rights, and it requires such claims to be resolved in an expeditious manner. For those reasons, the court should proceed with addressing respondents' anti-SLAPP motion on the merits as soon as possible. Okay, so they want them to drop the anti-SLAPP portion, or they want them to dismiss the anti-SLAPP portion, because it's not constitutional. Because they use so many words to say, you know, like this stuff. It's a little bit confusing as to what they're actually trying to say. Maybe lawyers have like a better interpretation of what they're trying to say. But to a layman who did not actually go into law, you know, it is confusing what they are actually trying to say, other than the presiding disciplinary judge needs to address respondents' anti-SLAPP motion. I don't. Okay. Yeah, they should address it. They're taking a very long time to basically address any filings, but it seems like that's kind of par for the course. This entire Owensverse saga is the first court case that I've ever watched outside of like a crime show like Law and Order, SVU, or Criminal Minds, or even Dexter, anything like that. So I am not overly familiar with all of these filings and stuff up until this case. What I have noticed so far is that judges are taking a ridiculously long period of time in order to, respond to any filings by anyone. So it's like they just keep letting things fly, and then eventually they respond one day. So after this, more recently, at the end of June, we received, this was filed to the docket. Share screen. Yeah, I X'd out of it before I actually switched the tab. But anyway. Okay. Okay. So I was just making sure that I was like keeping up on the chat. It's a little bit intimate in here in this chat today, so I appreciate those who are here. And also the chat is going super slow, so I can actually keep up with it. But do feel free to chat, feel free to comment. I will most likely get to it. So so this one was filed June 22nd, 2026. It is the order regarding the motion to dismiss. Oh my God. Bond is playing with a ball that's like right outside his little beach shack cardboard house down there, and it just scared the actual crap out of me. So, not the actual crap, okay, but scared the crap out of me. Okay. The presiding disciplinary judge. Okay, confirmed. Very good call. Say Cheese, who is hopefully watching on replay crew. The presiding disciplinary judge has reviewed the respondent's motion to dismiss and alternatively the motion for summary judgment, statement of undisputed material facts, and affidavit of David S. Gingles in support of respondent's motion to dismiss / summary judgment, all filed April 14th, 2026. In this ruling, the presiding disciplinary judge is only addressing the respondent's motion to dismiss. The alternative request for relief will be addressed separately if need be. On April 30th, 2026, the presiding disciplinary judge issued the briefing regarding motion to dismiss order to provide the parties the opportunity to file simultaneous briefs regarding whether the Arizona Supreme Court's exercise of its constitutional authority regarding attorney discipline precludes the respondent's requested application of this rule legislation in this matter. The respondent filed a brief on May 4th. Oh, did I miss the May 4th one, or was that the May 4th one? I thought that was dated April something. I only read that one. There were a few different documents. Well, as it says earlier in this document, there are several motions that were all filed on the same day. I just read the one because I just don't have the patience with my ADD. This is why I couldn't be a lawyer. Okay. So respondent filed all the briefs, blah, blah, blah. These briefs have been considered in the order herein. The ordering paragraph of the briefing order is stated as following. It is ordered providing each party of the opportunity to submit simultaneously a brief on this specific issue alone that is no more than 10 pages in length and must be filed with the disciplinary clerk no later than 4 p.m. May 21st, 2026. Despite the order's indication that the briefing opportunity was a simultaneous one, respondent filed a document labeled Response to State Bar's Brief regarding applicability of this law to lawyer discipline proceedings on May 20th, 2026. Okay, so the day before it was supposed to be filed. While reviewed, the presiding disciplinary judge did not consider it in this order, as it did not conform to the PDJ's order, nor did respondent request and/or obtain relief in order to file such. Procedural history. Yeah, you mean David Gingles not following orders? What a shock. Everyone hydrate. Procedural history. On September 15th, 2025, the Attorney Discipline Probable Cause Committee issued probable cause orders regarding the State Bar file numbers, all of these numbers, which were attached to the complaint filed by the State Bar on February 17th, 2026. Thereafter, the State Bar filed an amended complaint against David S. Gingles as respondent on February 25th, 2026. Respondent Gingles argues that the bar seeks to discipline him for activities that are protected under the right of free speech and the right to petition, and therefore he may seek dismissal of the complaint pursuant to Arizona revised statutes, also referred to as Arizona's anti-SLAPP law. However, the complainant actually seeks findings of violation regarding all of the following: ethical violations related to respondent's violation of Judge Mata's February 21st, 2024 order. The State Bar allegedly, by engaging in the conduct set forth, respondent Gingles violated by knowingly violating Judge Mata's order and court rules by making extrajudicial statements that he knew or reasonably should have known would be disseminated by means of public communication and that would have a substantial likelihood of materially prejudicing the paternity case by using means that had no substantial purpose other than to embarrass, delay, or burden any other person and rule by knowingly violating Judge Mata's order. What was that footnote there? The PDJ has found regarding this specific violation allegations that the respondent Gingles' argument that the exercise of free speech alone in these proceedings is not legally valid defense. See order in regarding motion for partial judgment on the pleadings filed April 14th, 2026. His argument here continues to not acknowledge lawyers' agreed upon limitations, on their conduct and speech provided in Rule 41 by taking the oath and accepting the creed in addition to other responsibilities provided throughout the Arizona rules of the Supreme Court. Okay, so see, that's what I said. Lawyers are held to different standards, regardless of being an Arizonan. I didn't even know I mean, Minnesota's a Minnesotan. Why wouldn't Arizona's be an Arizonan? I don't know. Anyway, no substantial purpose other than to embarrass, delay, or burden any other person and knowingly violating Judge Mata's order. Violations based on respondents' effort to preclude Michael Maricini from testifying on June 10th, 2024. The State Bar has alleged that based on the conduct set forth, respondent Gingles violated this rule and this rule by unlawfully attempting to obstruct Clayton Eckerd's access to Maricini's testimony by using means that had no substantial purpose other than to embarrass, delay, or burden Eckerd or his counsel, and ER rule by engaging in conduct prejudicial to the administration of justice. Violations related to the respondent's disparaging comments about Judge Mata, the State Bar has alleged based on the conduct set forth, respondent Gingles violated ER rule blah blah by using means that have no substantial purpose other than to embarrass or burden Judge Julie Mata by making a statement with reckless disregard as to its truth or falsity concerning Judge Mata's qualifications or integrity, and by engaging in conduct prejudicial to the administration of justice and these rules, by failing to maintain the respect due to the court and the Judge Mata, and engaging in unprofessional conduct, including by making public statements about Judge Mata's qualifications or integrity that were objectively false or made with reckless disregard to their truth or falsity. You mean comments such as, "Look at me, Daddy, I'm a real judge now, tee-hee." Oh, hey, Jupiter Janes, how you doing? Hope all is well with you, Queen. Yeah, so he's definitely violating some stuff. If he was talking about someone else's case, maybe he has the right to say whatever he wants to say, however he wants to say it. Like if he was on, doing some law tube things, he would maybe have that right. Unfortunately for him, it was a case he was actually working on at that time. So I don't think that applies. And it seems like neither does the PDJ, which is the presiding disciplinary judge. See, I already forgot the acronym. Okay, anyway. Such a problem. My brain. Ugh. Cindy says, in other words, JFC was right all along. Yeah, but we're renaming it to JF Volo over here on this channel because it's not just about Clayton. It's about everyone. But yes, the cult of JFC indeed was right about this, and he was wrong. Is anyone surprised? Because I certainly am not. That is for bloody damn sure. Okay, violations related to respondents' disparaging comments. Wait, I read that part already. Made with reckless. Okay, violation related to respondents' disparaging comments about members of the public. The State Bar has alleged, by engaging in the conduct set forth, respondent Gingles violated rule this one by engaging in unprofessional conduct. Oh, Jupiter Jane says, it's my bedtime. I'll catch the rest on replay. Just wanted to say hello. Oh, well, thank you for stopping by. Hello, and have a wonderful sleep and some excellent dreams, not any hellish ones. Bye, love. Okay. The State Bar has alleged, by engaging in the conduct set forth, respondent Gingles violated Rule 41, blah, 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 by engaging in unprofessional conduct. Hey, Rob says, I'm doing great. Thank you. Oh my God. And it's spelled right. Did you actually type that in, or did you text to speech and it finally got it? Asking for a me. Okay. Unprofessional conduct. Yes. We can, I think, all agree on that, much like the entire internet agrees that Laura Owens is a criminal. So there's that. The only time anything or anyone has ever united the entire internet. It's this case. Oh, goodness gracious. Oh, okay. Hey, Rob, typed it. Aha, see? Maybe if you add the word Hellville to your dictionary, when you say it, it will like register to text to speech or something like that. I don't know. Violations related to respondents' pursuit of meritless claims, false information in an affidavit, and presentation of Owens' false testimony / changing versions of events. I haven't actually read this yet, so I'm pretty excited about it. Also, I did watch Bruce's live, but I was super sleepy when I started it, and I just kind of like kept nodding off a little bit. So I need to go back and rewatch it. Maybe from my other channel, so it gives him more watch hours and stuff. I don't know if it matters at this point now that he's monetized and everything, but I think I'm going to go and do that. But Rob has to go and do something hellbills because you do not look like a Harville. Okay. It's just going to make me chuckle every time. It really will. It's so funny. Oh my goodness. Well, it says all the watch hours all the time. Yeah, exactly. I'm going to switch to my other channel and watch Bruce's live from that channel as well. So, and then I will also watch echoes from both of my channels, like I did a la Couch Court, and do like 3 times speed on my phone, and then like 1.5 like I usually do on my on my TV. Yeah, good answer. Okay. Yeah, I'm not sure. I'm not sure all the rules, how it all works. I just know that the way they have set up hype is really stupid. That's my opinion, allegedly. Anyways, yeah, so all the violations. The state bar has alleged, based on the conduct set forth, respondent Gingles violated this one by failing to act with reasonable diligence in representing Owens. Very fair. We all agree with this. By a different by asserting or controverting issues when he did not have a good faith basis in law and fact for doing so. That was not frivolous. Yeah, I think we all agree on that too. Different and B, by knowingly failing to take reasonable remedial measures when he knew that Owens intended to was engaging in, or had engaged in criminal or fraudulent conduct based on the paternity case. That one. That rule. By knowingly disobeying an obligation under rules of the court, other rule. By engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. Different rule. By engaging in conduct prejudicial to the administration of justice, and rule this one by knowingly violating any rule or order of the court. So all of these. Violations related to non-meritorious appeal. The state bar has alleged by engaging in the conduct set forth, respondent Gingles violated this other rule by failing to act with reasonable diligence in representing Owens, by asserting or controverting issues on appeal when he did not have a good faith basis in law and fact. For doing so, that was not just frivolous, and by engaging in conduct prejudicial to the administration of justice. I think I all got to use such big words. Getting myself tongue-tied. Analysis. Respondent Gingles' motion relies upon this rule. In other filings, the parties seem to agree that this is a relatively new statute. Footnote being that rule that they literally are just talking about, generally referred to as the anti-strategic lawsuit against public participation statute, anti-SLAPP, was substantially amended in 2022. See respondent Gingles' reply to motion for leave to exceed page limits, because he can't do anything in a normal amount of pages. Page 2, citing State of Arizona versus Coert. Is DT determined April 14th, 2026? Because yeah, that would be extreme. No, wait. That must be filed. It was filed. Okay. It was filed by Gingles and or his attorney in aha. Okay, I am not seeing things. Good to know. Okay, Cindy is also seeing the flickering. I don't know what it's doing. It just flickered again, I swear. But I will need to get to the bottom of that, should I remember. Because I don't remember until I start seeing it again. So it's my problem. Anyways, yeah. So that just means that motion was filed on that day. So the parties seem to agree that this is a relatively new statute, and application in Arizona attorney disciplinary matters is a case of first impression. The presiding disciplinary judge notes that the statute provides the movant has an initial burden under this law to establish prima facie, whatever, proof that the legal action was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. A finding must be made that the movement that the movant, not movement, movant, has met his burden, or this burden, before the plaintiff in the action is required to file a response in motion to pursuant to subsection A of the statute. The presiding disciplinary judge has conducted a cursory review of respondent's motion and finds that the motion is accompanied by a statement of facts and an affidavit as directed procedurally under ARS this one. However, before the presiding disciplinary judge proceeds with a substantive review of these materials for prima facie showing, the presiding disciplinary judge finds that the review of the applicability of this rule in disciplinary matters must first be considered. Therefore, the PDJ begins her analysis with constitutional supremacy / separation of powers review. Respondent Gingles argues that the speech issue in the case bar's complaint, in the state bar's complaint falls within his free speech right and right to petition. Footnote, the PDJ has only received one previous motion attempting to rely upon the statute. However, the previous motion did not meet the basic procedural requirements and was summarily dismissed. Okay, ARS A provides any legal action that involves a person's lawful exercise of the right of petition, the right of speech, the freedom of the press, the right to freely associate, or the right to peaceably assemble, pursuant to the United States Constitution or Arizona Constitution. The person other than a state actor or an intervener may file a motion to dismiss or quash the action under this section. J1. Why are there always so many parts to these laws and rules and stuff? My goodness. Just make it simple. Simple and clear. That's another thing I didn't really like about the law. Like, I think I could be a loophole queen. I could read a contract and find that wording allows a loophole or something like that, like nobody's business. And I could easily blow holes through things. The issue to me is that it's just everything is so verbose. But again, if you find one thing, then you don't really need to worry about the whole rest of it. I mean, it's very much like a Gingles, school of thought with how he kind of approaches law, where he just finds one thing and then latches onto it without reading anything further. I would continue reading further, but I'm just saying that I could find the loopholes, and then like the other stuff doesn't really matter as much, but I would still read it. I don't think he continued reading after he thought he found a loophole, even though it was clearly described later on to not be an actual loophole. But anyway, I digress as always. Okay, so whatever this part of the rule is, defines the term legal action as follows. A, it means any of the following. 1, any civil action claim or cross-claim. Any civil action claim, cross-claim, or counterclaim for damages other than nominal damages. Any criminal prosecution except for a drug trafficking offense included in Title 13, Chapter 34, or 31 or 34.1, a riot or a serious offense or violent, or this is such a run-on sentence. Can we work on that, please? Or aggravated felony as defined in Section 13706. 3, any written investigative demand pursuant to Section 38-431-06, or other compulsory legal process, or any regulatory or administrative action or by a state actor. That all means nothing to me. That's like a layman right over my head. Anyway, Rule 48A, Arizona Rules of Supreme Court, provides the nature of disciplinary proceedings are neither civil nor criminal, but are sui generis. I don't speak Latin. I'm assuming that's how that's said. Therefore, the PDJ holds that the disciplinary action at issue would not fall within the definition of a legal action under ARS. He didn't read it through all the way. This is how we got here. Under ARS 12 751, J1, I, and II. So many letters and numbers. Respondent Gingras argues that this case involves A and 3, a regulatory or administrative action by a state actor. While the respondent does not cite legal authority he is relying upon, assuming such is accurate, the PDJ finds that ARS blah, blah, blah reflects that the Arizona legislature intends for this statute to apply in disciplinary proceedings. The PDJ reflects that the Arizona legislature intended for this statute to apply in attorney discipline. Oh, is that in favor of Gingles? That can't be right. He doesn't win things. I find that suspicious. The PDJ will assume, for purposes of conducting this analysis, that at least some of the complainant's allegations involving alleged violations of Arizona rules of professional conduct and or the Arizona rules of the Supreme Court for what would generally be found to be a person's lawful exercise of the right of petition and or the right of free speech pursuant to United States Constitution or Arizona Constitution. Emphasis added. Why did they put that in? Why did they put that in parentheses? We could see because it's bolded. However, the instant case does not involve a general member of the public and their actions. Rather, this matter is centered on the state bar's pursuit for discipline of an individual licensed to practice law in the state of Arizona for alleged violations of the lawyer's obligations imposed upon lawyers by the Arizona Supreme Court's rules. Footnote: the PDJ notes that the court has distinguished the rules regarding lawyers from those enacted by the state administrative agencies. As such, is pursuant to legislation when this court promulgates good grief rules pertaining to attorneys or to court procedures. It does so pursuant to its own constitutional authority over the bench, the bar, and the procedures pertaining to them. From the motion and brief, it is unclear which conduct alleged in the 184 paragraph complaint that the respondent Gingras is affirming and arguing was lawful exercise of a constitutional right of either free speech or to petition. Because why would he be succinct? Why would he be accurate when he doesn't have to be, I guess? Everyone hydrate. Okay, constitutional authority. What page are we on? Why doesn't it clearly show? Okay, we're on page 9. Okay. Constitutional authority. It's a well-settled, I can read sometimes. It is a well-settled matter of law that the Arizona Constitution, article this one, provides the court administrative supervision over all the courts of the state, including attorney discipline. The court has consistently found that the practice of law is a matter exclusively within the authority of the judiciary. The determination of who shall practice the law in Arizona and under what condition is a function placed by the state constitution in this court. In fact, the great weight of authority is in accord with the proposition that the ultimate authority for defining, regulating, and controlling the practice of law is vested in the judiciary. Okay, so the judiciary has all the power despite the separation of power or duties. To this end, the court has issued rules such as Rule 34, the application for admission, regarding the admission to practice law, Rule 41, duties and obligations, members or lawyers, which provides duties and obligations, including the oath and creed that a lawyer must accept as part of admission. Rule 42, Arizona Rules of Professional Conduct, provides ethical rules for lawyers' practice. Violation of Rule 41 and 42 are subject to disciplinary proceedings pursuant to Rule 54. Grounds for discipline. Discussing the court's ability to promulgate rules regarding its constitutionally prescribed administrative responsibilities under Arizona Constitution Article blah blah blah. See also Hannock versus O'Neill. Clarifying that the court's authority specifically includes attorney discipline. Okay. Rule 41, Arizona R Supreme Court, places obligations upon a lawyer who chooses to be admitted to practice law in Arizona regarding such things as the written manner, including word choice, that the lawyer may use, the veracity of statements provided by the lawyer as an officer of the court, and the tone and purpose of the words stated or written by the lawyer. We all know the purpose of those words, okay? It does not fall under, high professional esteem. Yeah. Wallace, I was literally actually about to Google what that word means. Promulgate is on your word of the day calendar, courtesy of Gingles, I guess. Yeah, literally. Actually, not courtesy of Gingles because, well, I guess, yeah, he used it in his motion that one time. But then this presiding disciplinary judge decided to use it 45 more times. So rude. What is this word? Okay, wait, we're gonna find out what this word means. Okay, promulgate. Means to formally and publicly declare, publish, or put out a law, regulation, or idea into effect. It's the past tense. Well, I didn't ask for the Google past tense, the word I was writing in. How rude. It's the formal term frequently used in legal, governmental, and institutional contexts. Okay. However, it's the first time that I have come across it in this crazy case. But anyway, I digress. Okay. So, and I know I didn't show that. I just figured it would be quick and I wouldn't have to. Wallace says, oh, that's so meta. You're now promulgating the word promulgate for all of us. Yeah. You're welcome. I promulgated for you so you don't have to promulgate later. That's what I'm here for, guys. Promulgating, of course. Of course. As one does. Hellishly. Okay. Goodness gracious. I don't even know where I was. The places obligations upon a lawyer who chooses to be admitted to the practice of law in Arizona regarding things such as the written manner, including word choice. Oh, word choice such as, look at me, daddy, I'm a real judge now. Tee-hee. That was a choice. That was certainly a choice. That the lawyer may use, the veracity of the statements provided by the lawyer as an officer of the court, and the tone and purpose of the words stated or written by the lawyer. Comment 1 goes on to educate lawyer, whether or not engaged in the practice of law, should act honorably and treat others with courtesy and respect. A person is not required to practice law in Arizona. However, once one elects to do so upon admission, the person has agreed upon these directives and restrictions on one's general personal rights. I would say read the room, but he didn't read the oath. So he didn't read the oath. He did not understand what he was agreeing to. Oh, those many years ago, and it's gonna bite him in the ass now, isn't it? Yeah. Okay, well, however, once one elects to do so upon admission, the person has agreed upon these directives and restrictions on one's general personal rights. In addition, The court's rules provide for the enforcement of these responsibilities or obligations. Rule 55 places obligations on the state bar in evaluating and investigating all information coming to its attention in any form, alleging unprofessional conduct, misconduct, and incapacity. The ADPCC regarding considerations, and I've already forgotten what that means. Something about Arizona, something. Wallace says, imagine if we were all obligated to practice law in Arizona. Weird dystopia, that would be, yeah, it would be really, really weird. I think a good amount of us would do a better job than some other people that we know. Gingles, perhaps. And once again, I know that he has recently suffered a loss, and, you know, it is tragic that his wife passed away. I don't know the nature of their relationship at that time, and it is not my business to know. It doesn't negate, and I said this on my first stream, and I'm sure I've said it since, but it doesn't negate him being a shitty person. It doesn't. I'm not going to, like, go in on him, like, necessarily, but I am going to go in on his behavior and some of the stuff he's done here and there. So, you know, if you think that I'm being really unfeeling or whatever, it's not about that. If you were a shitty person before something tragic happened to you, you were a shitty person, and people are allowed to talk about that, in my opinion. So anyway. Everyone hydrate on that note. Okay. Alleging unprofessional conduct, misconduct, and incapacity, the whatever that acronym means, something about Arizona, regarding considerations beyond probable cause before authorizing bar counsel to prepare and file a complaint against a respondent. Once the matter proceeds to an evidentiary hearing before a hearing panel, if the panel finds a violation, Rule 58J and K, J and K, like JK, I'm 5. Guide the panel, including, if appropriate, to conduct a proportionality review. No, proportionality review. I think I said it right this time. In determining the sanction to impose. Separation of powers. Article 3 of the Constitution of Arizona provides the powers of the government of the state of Arizona shall be divided into 3 separate departments: the legislative, the executive, and the judicial. And except as provided in this Constitution, such departments shall be separate and distinct, and no one of such departments shall exercise the powers properly belonging to either of the others. Here, the statute seeks to regulate attorney discipline complaints involving the lawful exercise of the right of petition and the right of speech, potentially resulting in the dismissal of the complaint. When a statute and court rules conflict, given the court's constitutional authority, the rules adopted by the court prevail. While the legislature may be, I can't read anymore apparently, while the legislature may by statute regulate the practice of law, such regulation cannot be inconsistent with the mandates of the court. And some other numbers and whatnot. To put the matter in simpler language, the rulemaking power rests in both the courts and the legislature. Aha! When the legislature enters that field, the courts will bow to its judgment, so long as these rules accord with the proper administration of justice. When, however, it appears that the legislative rule unduly hampers the court in the performance of the duties imposed upon it by the Constitution, the rules adopted by the court will prevail. Emphasis added. Okay, I appreciate the emphasis added part here. I will say. Okay, and then a bunch of legal rules and stuff. The PDJ understands that the court favors an interpretation of the legislation so as to be constitutional whenever possible. However, the PDJ finds that the ability to discipline a lawyer for behavior, I don't know why this is formatted differently, to discipline a lawyer for behavior that the state bar and the panel, well, the state bar, the ADPCC, and the panel finds violates the court's rules is an important and necessary function in the court's disciplinary process. Neither respondent Gingres's motion nor brief provide a legal analysis as to how the state could be as to how the statute as to how the statute could be applied consistent with the court's existing rules with regard to a lawyer's professional obligations and duties. Instead, Mr. Gingres' brief simply seems to state that the statute supplements the court's rules rather than conflicts. Stating it does not make it so. Why wasn't that bolded and instead emphasis added? That should have had some emphasis added. I love it. Jazz hands. That's emphasis. Oh my God. Given the absence of such a showing, the PDJ finds that interpreting the statute as applying to attorney disciplinary actions would unnecessarily implicate constitutional questions and unduly hamper the court's constitutionally imposed duties. The PDJ finds the following. The movant, respondent Gingres, has failed to demonstrate that the statute does not unduly hamper the court's exercise of its constitutional authority regarding the practice of law in Arizona. Independent of such a showing, the PDJ has been unable to determine how to apply the statute in a manner consistent with the court's rules regarding the attorney discipline. For these reasons, it is ordered denying respondent Gingres's motion to dismiss filed April 14th, 2026. Given that this is a matter of first impression and the effect of the PDJ's ruling herein provides on the instant case, the PDJ understands that a party or both may wish to file a petition for special action with the court. Therefore, the PDJ will not issue any additional procedural schedule in this matter at this time. However, if a petition for special action is not filed within the next 30 days, the PDJ will thereafter proceed with issuing a new procedural schedule order in this manner. Okay. I mean, they get a little bit snarky with Gingres, which I appreciate, of course. I'm a little bit unclear exactly what obviously they're denying the dismissal, but it was just a partial dismissal that was requested, I believe. So I guess they're just, I also am not entirely sure what they mean by schedule. Because I know that some of the, I'm assuming they're not talking about the actual dates involved, because I know that some of the hearing dates were vacated or what have you. So I don't think that's what they're talking about. I could be wrong. But either way, they've denied something that Gingres asked for is basically the answer here. I think maybe because Gingres or Gingles or whatever you want to call him is so extremely verbose and uses so many rules and examples and cases to try to prove his point, none of which ever actually fully apply. Maybe they have to respond to each and every one of those, and that's why they are being so verbose. I'm not sure exactly, but it seems like that might be kind of like why they answered in such lengthy terms. Because by answering in such lengthy terms, it's a little bit like difficult for a layman to understand what this is saying, other than that it's rejecting something that he asked for. So, yeah. All right. So earlier this week, I think, or I guess end of last week. I think on Friday, some stuff hit the docket in the Owens case. And I was looking for that, but I couldn't find it. Laura filed for indigency again. Let me go to the Reddit because I can't find it on the Volo site. And the first thing that pops up is that Love Trapped is named one of the best shows of 2026 by Apple Podcasts, and it is so good. You guys, if you haven't watched it. It's a podcast. You can't watch it. If you haven't listened to it yet, I don't know what you're doing. Okay. I don't know what you're doing, but if you haven't, you should. It is so good. And I have suggested it multiple times to many, many people. And I've gotten at least 2 different people hooked on it, probably more than that just haven't like told me that they've gotten hooked on it. So I might be a micro influencer. Micro meaning 2. It's fine. Okay, so let's open that up. And whenever that's properly loaded. It's white. Yeah. It's so white. Hurts my eyes. This is why I have sunglasses on. My eyeballs hurt. Okay, let me share my screen and blind you all as well. You're welcome. Okay. So this is the second time in this case that they are filing a motion for declaration of indigency and eligibility for court-appointed experts and investigations. The first time they filed it was when she was being represented by the public defender. And then she hired counsel with money. And when Llama and Buffy were talking about this over on Couch Court, and True Wine with Crime and Crime Time. I can't speak. Sorry. True Wine and Crime Time. When they were covering this earlier, they said this is normal and should be granted, assuming she was being represented by a public defender. However, because her family is paying for an attorney, this is problematic. Additionally, I do remember what was said in the bankruptcy filings as well, and a lot of what is in this document is actually at odds with that. So Wallace says, she's so poor, so poor. Just ignore that she has a new car and paid attorney. Yeah. Poor Laura. How bad for you I feel. I feel so terrible for you. Said no one ever. Anyway. Yeah, so a lot of the things that she says in here are in opposition of what she said in her bankruptcy filings and in the creditors meeting with Queen Jennifer. So Yeah, and Cindy says, and goes to berries and horse shows. So there's that. Yeah, and owns horses and cares for horses, and they are all still alive. So assuming that they are paying for their care. And somehow she is not able to afford the basics of being a defendant outside of just paying for a lawyer, which makes no sense to me. And also why she's still allowed to keep these schedules, the lifestyle. I mean, honestly, I don't know why she's not waiting behind bars. Usually poor people have to wait in prison for their case to be heard. I know this was not a violent case, but
correct. That's a very minor thing.
Goodness gracious. It might not be violent, but I just don't get why at every turn she's being treated with kid gloves. It really pisses me off because no one else in her position would be treated so kindly by the courts. So I don't get it. But anyway, let's all take a moment and feel bad for Laura. Poor Laura. Okay, second over. Okay, so motion for declaration of indigency and eligibility for court-appointed experts and investigations. Hopefully she gets a really small budget because she's already wasted a bunch of money of Arizonans by getting a public defender before and then firing him and hiring someone else. So hopefully that has eaten into her expert budget. Okay. I don't know where my mouse went. Okay, there it is. Defendant Laura Owen. Someone does not proofread. Okay. Defendant Laura Owen, through her attorney, hereby respectfully requests this court, pursuant to rules, these ones, issue an order declaring her indigent and eligible for court-appointed assistance in the preparation of her defense. The indictment includes 14 felony counts, and if convicted at trial, Ms. Owens could be facing decades in prison. And whose fault is that? There's a certain person who could have gotten out of it way before it made it anywhere close to here, by just writing a public statement saying that she was never pregnant by the bachelor. But that didn't happen, did it? That will never happen. Whoops, I didn't mean to play twice, but anyways. What a ridiculous human. She might not have killed anyone, but she could have driven someone to do that to themselves. And I think from what Clayton said and from what Mike sort of implied a little bit, she might have come pretty close. So anyway, she deserves decades in prison, and that's the only way to keep the male population of Arizona safe from her anyway, to keep her locked up through the rest of her baby making years. That way she can never ever claim she's pregnant ever again. So there's that. Defendant is currently unemployed and living with her parents at their home, where they assist her with all of her living expenses. Why is she unemployed still? Prior to 2025, when charges were originally brought in the previous case, charges were brought only in 2025. The original 7 charges were brought earlier in 2025, and then the second set were brought in November 2025, right after the DVRO case against Michael Maricini were dismissed due to her not showing up. Despite being able to show up in California, which is where the trial was being held, despite her being able to show up in California over and over and over and over again to see her sister, she's apparently unable, and attend horse shows, of course. She's apparently unable to go to California to, bring her case that she brought after being ordered to be there over and over again. I don't know how she's able to go visit her sister all the time, but anyways. They were all brought in 2025 though. Prior to 2025, when charges were originally brought in the previous case, and now it goes to black. Oh, thank goodness. Ms. Owens had a good job and a solid income. Okay, where's the proof of that? I would like the proof of that. I'm going to need evidence, exhibits, Exhibit A, Exhibit B, because she said in the bankruptcy hearing to Queen Jennifer herself, I have never had a 1099 or a W-2. So, which is it? Which is it? She had a good job and a solid income, or she had none of those things. Two things cannot exist at the same time, as they are in direct opposition with each other. So, which is it? I want proof. Write me out. She has since lost all previous sources of income and completely relies on her family for financial support. What income did she have? I want pay stubs, and then I want them submitted to Queen Jennifer. Thanks. All of her savings, assets, etc. Not all. She still has Sirocco 34, whatever the hell the horse's name is. And also she has like 6 other horses at least, and then there's the one that's being leased out for free and whatever, all the things. All of her savings, assets, etc. have been expended on her multiple legal battles, all of which were of her own bringing, including this case, which was not of her bringing. This one, however, was because of the ones she brought. While defendant's parents provide the bulk of her support, including providing Ms. Owens a monthly allowance to cover the expenses listed in the Affidavit of Financial Information, they themselves are currently in federal bankruptcy proceedings. Again, they brought that. And Queen Jennifer and the judge, Queen Judge over there in bankruptcy court on chapter 11, they are both, perplexed as to these people bringing all these bankruptcy cases and then dropping them 5 minutes later just to save their house, when that is expressly not how bankruptcy is meant to be used. It's not that kind of shield. Anyway, while it is not listed on the affidavit, it should be noted that victim Clayton Eckerd was awarded approximately $200,000 in attorney's fees and costs against Miss Owens in the family or paternity matter, blah, blah, blah. That debt is still outstanding against Miss Owens. Any income defendant receives and any assets she acquires are subject to garnishment toward the payment of that debt. Okay. Yeah, as they should be. I mean, this is basics. And it's got to be well over $200,000 by now, because it's $200,000 plus interest. Or it was like 190 something and change plus interest. So add interest on, it's definitely well above 200,000 at this point. Got to be, right? Someone do the math. That's not my job. Ms. Owens now respectfully requests this court to declare her indigent and eligible for court-appointed assistance in the preparation of her defense. This will include the assistance of an expert in digital forensics and may include additional experts, such as an investigator and/or a mitigation expert. The defendant submits that, as with all other indigent defendants, the specific assistance will be obtained through the office of court-appointed counsel. But she has counsel that is not court-appointed. She has paid counsel. So this kind of makes no sense, similar to what Llama and Buffy were saying in their stream. This is not making sense. Either you're indigent or you're not indigent. And if you're indigent, you can't pay for a private attorney. So you're not indigent. I think you give up your right to be called indigent when you are declared indigent, and then you hire a really expensive attorney and continue to pay the really expensive attorney, as far as we all know anyway. I do suspect that his money is going to probably be clawed back, because obviously they're literally saying in this here, in this filing right here, I think. We'll see if it gets mirrored. Right here. I'm not sure which way it's going to mirror things, but anyway, they say that the fees are being paid by her family, but they say that they never said that. They didn't declare that in their bankruptcy, that that's where their money is going. Is that all coming directly from the GoFundMe, and that's why they didn't mention anything? Like, it doesn't make sense. Anything this family says is in opposition with something else they have said. They themselves have said. Miss Owens now respectfully requests the court to declare her indigent, blah, 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 but she's not indigent because she's paying for an attorney. But anyway, discussion. Rule 6.4 of the Arizona Rules of Criminal Procedure sets forth the procedure of the court to determine whether a defendant is indigent. The defendant therefore requests this court to issue an order declaring her indigent and eligible for court-appointed assistance in the preparation of her defense. Everyone is entitled to the best defense that they can possibly get. Most people don't get what they're entitled to. I don't see why she would be different in that regard. We do want to limit her ability to try to appeal. However, this is bullshit. Let's just call a spade a spade. This is bullshit. May the fires of Hellville compel her. She is not indigent. She just isn't. Good grief. Oh my God, these people, they're such liars. Okay. We don't want her to appeal, but either she can pay a private attorney or she can't pay for anything. It's one or the other. If you can pay for a private attorney, you can also pay for experts. Where is that money coming from? You know, if her parents are now bankrupt, where is that money coming from? There's no way that they're just stopping paying looters. I mean, maybe in the next couple of days, we're going to see a withdrawal of counsel from him or a notice of candor to the court or something. Obviously, he did not do due diligence on all of these things. While he did make an appearance of observation only in the bankruptcy hearing. Which one was that? I think it was the one for the dismissal. Correct me if I'm wrong. But anyways, he might have appeared in that, but he obviously seems to have not done appropriate due diligence on her parents' bankruptcy, or if he was one of the observers, like I titled myself. If he was one of the observers in the parents' case, then why would he write this? Because that is either throwing Laura fully further under the bus or throwing her parents fully under the bus. Obviously someone's lying. I mean, obviously they're all lying. Logic does not exist here. Never mind. Okay. The paramount importance to an indigent defendant of an investigator, I can't speak the English, of an investigator and other services was recognized by the Ninth Circuit Court of Appeals in this case. Here, the court's analysis first surveyed the constitutional principles requiring the indigent defendants be provided with assistance when charged with a criminal defense. See this other case. Indigents Sixth Amendment right counsel applicable to states through 14th Amendment. Indigents must be provided with transcripts for appeal of proceedings for appeal. Okay. And indigents must be provided counsel on appeal. Are they saying they're going to appeal? It seems to be mostly applicable to appeal. Thereafter, the Mason Court stated that the principles steadfastly announced in the Supreme Court decisions reviewed above require us to hold that the effective assistance of counsel guarantee of the due process clause requires, when necessary, the allowance of investigative expenses or appointment of investigative assistants for indigent defendants in order to ensure effective preparation of their defense by their attorneys. The court concluded that the failure of the state to provide such assistance when needed results in ineffective trial. Just making sure I shared my screen because I suddenly had a panic attack that maybe I didn't. Okay. Mid-sentence, ADD, that's how it goes. The court concluded that the failure of the state to provide such assistance when needed results in the ineffective trial representation. See generally State v. Cornell. Trial court has both constitutional and statutory duty to provide the indigent defendants with certain essential tools of trial defense. The thing is she still considered indigent when she went from definitely being declared indigent by the court and then appointed an attorney? Is she still considered indigent when she did that and then she went and hired an attorney that was not appointed by the court? Like, I'm confused by her current indigent status because it seems like she shouldn't be continued to be considered indigent once she hired counsel. I think. I can't say for sure, but I think that. And just scrolling a little bit, thankfully, this lawyer is much more clear and concise than a certain Gingles. Yeah. I don't think this applies to her personally based on her own actions. In this case, the defendant is facing charges that could potentially send her to prison for many years, all of her own doing. To deny her the assistance of an investigator or certain expert witnesses could be tantamount to denying her right to fully investigate the crimes she faces or the defenses that might be available to her solely because of her indigency. This would clearly be a denial of her right to equal protection. See this other case. Denial of a right because of indigency violates Equal Protection Clause. The United States Supreme Court explicitly condemned such allocations of rights based on wealth. In Griffin v. Illinois. Okay. Well, she did not allow her victims an allocation of rights, and she used her wealth against all of them. So I don't think she should be provided with this, but I know that legally she must be if she is considered indigent, which frankly, if I were the court, I would have a hard time declaring this bitch indigent again. after what has just transpired with the public defender and firing the public defender in favor of a paid attorney who is preparing this very document and being paid, I'm sure, a buttload of money for it. Anyway, in this case, the defendant is facing charges that could potentially send her to prison for many years. To deny her the assistance of an investigator or certain expert witnesses could be tantamount to denying her the right. Oh, I was way further down. Sorry. There can be no equal justice where the kind of trial a man gets depends on the amount of money he has. I agree with that sentiment, but not in this case. B, the equal protection clauses of the Arizona and United States Constitution guarantee the defendant the services of an investigator and other experts services at the state's expense. In Mason v. State of Arizona, an indigent feral, she is feral, and her hair is feral too, but anyway. In Mason v. State of Arizona, an indigent federal habeas corpus petitioner alleged, I can't read anymore, oh my God, challenged the refusal of the state trial court to appoint an investigator in his homicide prosecution. The Ninth Court of Appeals stated quite clearly that unless the state provided Mason with an equivalent and fundamentally fair substitute for the normally available investigative services of the public defender's investigative staff, he was denied equal protection. The court further stated that a state court should probably, that doesn't seem very definitive, should probably view with considerable liberality a motion for such pretrial assistance. Yeah, so they can apply it liberally. They could apply this rule liberally. I think they should not apply it in this case. They should use their liberty to not to not apply it. But anyway, or at least to set the limit of the budget to be pretty low, I think would be fair. There can be no question that Miss Owens, an indigent defendant, a previously considered indigent defendant, okay, would be entitled to the resources of the public defender's investigative staff if she were represented by the public defender in this matter. Accordingly, the denial of an investigator appointed at the state expense would amount to a denial of equal protection under the law. This constitutes an independent ground for granting the defendant's request for declaration of indigency and eligibility for court-appointed experts and investigators. Again, I don't know where the status is of her indigency. I think it might have gone away when she hired an attorney, and I think that should be the case. So therefore, I think they need to redeclare her indigent before they can start demanding shit. Okay, C, the defendant is entitled to an investigator and expert appointed at the state's expense because a reasonable attorney would engage such services for a client having the independent financial means to pay for them. I think they're just hiding the reasonable independent financial means to pay for them. But anyway, in State versus Knapp, the Arizona Supreme Court considered what type of investigative and expert assistance must be provided to indigent criminal defendants. The court noted that the issue of the investigative and expert assistance to indigent defendants implicated three separate constitutional rights: due process, equal protection, and effective assistance of counsel. In determining what services were required to satisfy the due process guarantee of fundamental fairness, the court made reference to USC blah, 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 which provides for investigative and expert assistance to indigent criminal defendants in federal cases. Title blah, blah, blah provides that counsel for a person who is financially unable to obtain investigative, expert, or other services necessary for an adequate defense may request them in an ex parte application. Upon finding, after appropriate inquiry and ex parte proceeding, that these services are necessary and the person is financially unable to obtain them. Well, have we found that? I don't think we found that yet. Or again, as the case may be. The court shall authorize counsel to obtain the services. The standard for deciding what constitutes necessity under this rule is whether a reasonable attorney would engage such services for a client having the independent financial means to pay for them. You already said that, sir. And a whole bunch of different cases. The bar should be bold in seeking subsection authorizations, and the bench should be tolerant in entertaining and relatively generous in granting them. How nice is it for the bench to be tolerant in entertaining and granting them on the citizens of Arizona's dime? Anyway, Subcommittee on Constitutional Rights of the Senate Committee on Judiciary 90th Congress Second Session Report of Criminal Justice Act in the Federal District Courts, blah, blah, blah. Because there is no question that a reasonable attorney defending a similar case would engage the services of an investigator and or expert if the client had independent financial means to pay for them, Ms. Owens is entitled to the services of an investigator at the state's expense. You've already said that too. Courts should interpret statutes and rules providing for investigatory and expert services in a fashion consistent with the remedial purpose. Placing indigent defendants on a footing closer to that of prosecutors who have the resources of the government at their disposal. So the citizens of Arizona should have to pay for this bitch twice. They should have to pay for the state to investigate her, and then they should also have to pay for her to investigate her, despite her being on film and in writing, admitting to things dead to rights. Okay. There's something fundamentally wrong with that, in my opinion, but I digress. Sailor, Supra, whatever that means. In this case, the prosecution has utilized investigators from the Maricopa County Attorney's Office and additional expert witnesses to establish its case against Ms. Owens. It would be manifestly unfair to deny the defendant the services of an investigator and other necessary experts on her behalf under these circumstances. I think all Mr. Loiters needs to do, Loiters, whatever his name is, needs to do is just like watch the hearings. All of them. The hearings for the restraining order granted by Duty, the shitty Duty, and Judge Gelkatsis and Judge Mata, and I think he would be resigning from this case right away. But anyway. This is so stupid. D. The defendant is eligible for court-appointed assistance because she is indigent, even though her family had the resources to retain counsel. The defendant is similarly situated to the defendant in Nat v. Hardy, whose family was able to retain private counsel for him, but who was himself indigent. There, the Supreme Court stated, the mother in the instant case had no legal obligation to provide legal counsel for the defendant, and the determination of indigency must be based on his financial condition and not that of relatives and friends. Did that person have a job ever? Asking for me. Because she's never had a job and she has obviously no plans on ever having one. So I don't see why the court should like grant any of this, considering she has made no effort to try to fix the situation on her end at all in any way. But anyway. The defendant is not asking this court for appointed counsel. The fact that her family was able to take on the burden of paying for a private counsel suggests only that their efforts are saving the county the expense of providing her with a public defender. The county has already expended a lot of money in providing her a public defender. She just decided to catapult over that and hire her own lawyer anyway, after costing the county a shit ton of money. I hate her. Anyway. It in no way detracts from defendant's ability to access the full range of resources that would be available to her along with the other indigent defendants. This is especially true where, as here, a defendant has been charged with serious offenses. In which the investigation of the charges and possible defenses require the assistance of an investigator and expert, and where the denial of such services would be prejudicial to the client and a violation of her due process and equal protection rights. Again, like, he doesn't need to ask for all this. All he has to do is watch the hearings himself and read the legal documentation himself to know all of these things about her. It does not, like, they don't. Anyway. Conclusion. For the foregoing reasons, defendant hereby respectfully requests this court issue its order declaring her indigent and eligible for court-appointed assistance in the preparation of her defense. Thank you, Christian, honestly, for saying what needs to be said in your mind anyway, in less than 30 million words. I think we all appreciate you. Thank you for that. I disagree with all of this. I reject this. Who am I to reject it? But I do. Damn it all to Hellville. I reject it. I think eventually he's going to retire from this case. I do wonder if he, the previous public defender, and the previous paid counsel will all poison the pool of lawyers in the area, of paid lawyers, I should say, to not take her case and force her to take a public defender once again. I think that would be the best thing for everybody involved. I mean, yes, it will cost the state more to provide her with counsel. However, either you're indigent or you're not indigent. And I know that last argument there was specifically regarding someone who was too poor to, pay for experts and stuff, but was receiving family money for counsel. But did that person's family also file for bankruptcy and lie about a bunch of things in those filings? Maybe it's time that the state adds some more defendants to this case. Since they are accomplices anyway, why not? Anyway. That's all I got for you. I hope you guys have enjoyed my take on this. I am not a lawyer. I am not a therapist. I'm an armchair lawyer and therapist. I do not understand some of the big words. Sometimes I look them up. I hope you appreciate getting educated along with me. Yeah, so I didn't see a whole lot more roll in the chat. So I think a lot of you have probably hopped over to Echoes, but those of you who are here, I really appreciate it. I will also be going to Echoes just after leaving here. I haven't figured out how to redirect to like raid to someone else. I wonder if there's like a I don't know where I would find that. I wonder if that's in YouTube Studio or something, because I had to accept I had to like accept the raid, accept the option to be rated or whatever, in YouTube Studio. So I wonder if it's in there, if I can like send you guys over to Echoes and then like join myself after cleaning someone's food bowl. I am unsure. Let's see, community. And I forget where that was. Viewer post mentions, no. Comments, no. Oh, view channel. No, wait, that's not what I wanted to do. I'm gonna have to play around. But everyone, go over to Echoes. Say Hellville sent you. Leave a bunch of fire emojis in the chat or fire hearts or devils. Okay, Cindy says, thank you, Hellville. I'll be going to Echoes too, but we'll just be listening. I need to give my eyes a rest. Yeah, this is all very blinding. But I'll be watching them while I play some games on my phone and stuff like I always do, because my brain has to be doing more than one thing at a time. The more than one thing apparently can't be figuring out how to send you guys over to another channel. I have no idea how to do that yet. I'll have to look into it. But I appreciate you guys being there, and go over to Echoes and have a wonderful night and a fabulous rest of your week that is upcoming. Bye, guys. Thanks for coming to my TEDx talk.